I'm happy to introduce attorney Sarah Barnes. Sarah lives and practices in Madison, Wisconsin. Her practice has been a mix of private practice and corporate trustee work. Currently, she's general counsel to a national benefit services organization that also does corporate trustee work, where she handles all levels of trust and estate administration matters. In the next hour, Mary and Sarah will go over unique planning scenarios involving directed trusts, ask your opinion on solutions, and provide their own. Please submit your questions to Sarah and Mary throughout their presentation. We'll set aside time at the end to address them.
So really grateful to be here today, and Sarah and I are going to talk a little bit about directed trusts. I did get a question asking me to provide a link to the presentation of the 97 trusts, and I'm just going to mention that I am pretty sure that the presenters will be agreeable to that, but I will check on that and see if I can provide that. It was a pretty awesome list of trusts. So directed trusts we're going to chat about today, and it's kind of one of my favorite topics. I think they're all my favorite topics. People tell me I say that about every trust and estate topic. But directed trust planning, super important in that it's really, flexibility is one of the things I talked about in my earlier presentation. And directed trusts create quite a bit of flexibility as opposed to traditional trusts. One of the things is we have this huge period where there's going to be a lot of transition of wealth going on. And directed trusts provide a lot of opportunities to do some strategic planning in that regard. Modern wealth has gotten really complex. Even your basic investment account isn't really a basic investment account anymore. Clients want a lot of control and they want the flexibility. Trustees, on the other hand, they don't want to have all the risk and exposure, and there is a lot of liability that goes with being a trustee. We have regulatory and we have fiduciary clarity. There's a lot of statutes out there on that. Directed trust, one of the things I really like is collaboration. I had a client once say to me, "Mary, you're smart. You will never be everything to me, so the best thing you can do is build a network, know who to call when it's not you, and collaborate with all the professionals." So I think that's hugely important, and directed trusts create a great opportunity to bring minds together in the same room to build a structure that really works for clients. Family dynamics, very complicated. I've been practicing long enough that it was common that there was husband, wife, had been married forever, and you're planning for their kids. That's not a typical situation today. We have unique asset classes. There's going to be a presentation later today on that. I can't wait to hear that myself. The traditional trust was, hey, we have a settler created the trust. We have a trustee. The trustee's in charge of everything. And we have a beneficiary or beneficiaries. And that was as complicated as it got. Coming from that world early in my career, I'm a huge fan of the directed trust for a lot of reasons, but one of them is just that there's accountability when you have more than one role involved. So instead of having, hey, I'm the trustee and I have total discretion, I'm going to do what I want, and by the way, I'm investing everything in these assets that you don't really like, too bad. We don't see that happening when we start using directed trust. I see a lot better play between all of the parties in my practice. So the directed trusts, what they do, so what do they do? It says, okay, the directed trust says, we're going to take that traditional trustee role and we're going to divide it among different parties. This is one of the areas where 50 states, 50 sets of rules, even those who have adopted the Uniform Directed Trust Act didn't necessarily adopt it exactly the way it was enacted. The other thing I will personally say about state law, and I do a lot of trusts in South Dakota, Nevada, Delaware, but each of those states is constantly trying to compete with all the other states that are trying to improve their trust laws. And so what I've learned is if I do a South Dakota trust in 2025, I don't want to use the document that I created in 2024 because their law probably changed. And so if I'm going to do that, and I'm not licensed in South Dakota, but one of my partners is, so I reach out. What changed in South Dakota this year? It's really important to realize that in the directed trust context, I think it's correct, Sarah, that I can't really say,
Yes.
we can tell you everything you need to know about directed trust. So some of the conversation will be general concepts. Look at the state law for which you're drafting, whether it's the state that you practice in or whether you're working with co-counsel in a different state to create a document in a different state. So the directed trusts basically allow you to take that trustee role. So the trustee historically did investments, was in charge of distributions, pretty much in charge of everything. We now take and we divide that role up. So distinguish for a minute, and I do want to make this distinction briefly between what we call a directed trust and a delegated trust. So it's very common in a trust to say, hey, the trustee can hire somebody to deal with the real estate. So it's a bank trustee, they don't have a department that handles real estate, so we can delegate that to somebody else. That's a delegation. That is very different from naming a trust director who has the authority to direct the trustee with respect to what they do. So when we have a directed trust, what we do is we name an advisor or director who actually has the authority to tell the trustee what to do. If it's a delegated trust, then the trustee is still responsible. So if I pick a really bad agent and delegate authority to them, I still have the responsibility for that in my role as trustee in the delegated trust. In the directed trust, that responsibility can vary, but part of the goal is that a lot of trustees are, well, we really don't want responsibility for your really weird asset. So we want you to name a special holdings advisor to take responsibility for that particular bizarre asset that you choose to invest in. So the kind of legal background is that directed trusts have really been around in some form for a long time before we had the Uniform Directed Trust Act. So we have cases that go back a long ways that recognize attorneys would draft in some kind of advisor role. And I've included some of that in the outline that's in the materials if you're one of those who likes to dig into all those case details. But we will recognize things like protectors or advisors were recognized by the court. We have that codified under the Uniform Directed Trust Act, which has been adopted by 21 states, as I think is the current number. We have some states who said, hey, we're going to make a living out of having amazing laws for trusts and some of them for entities as well. And those are Delaware, Nevada, and South Dakota. And I have to admit that I'm a fan of their particular statutes. So to the extent states have adopted their own statute rather than the UDTA, most of them have used Delaware as a model. Nevada and South Dakota use that model to start, but both have quite a few variations, but they are very favorable to the directed trust. The Directed Trust Act does what we would call a balance of fiduciary accountability. Delaware emphasizes autonomy. So when I do the Delaware trust, a lot of times I might have both an advisor and a director. The advisor does not necessarily have the ability to tell the trustee what to do. The director might. And the liability that goes with each of those roles is very different. So we have in the materials some details about drafting, but drafting about the roles and the liability is extremely important. So you just don't want to throw a trust director or a trust advisor into a document without being clear exactly what is their job and what is their liability and what is the relationship between that person and the trustee. So typical types of advisors are the investment direction advisor. And that is probably one of the places where this became really popular, the directed trust concept, is your settler really didn't want to let go of controlling the investments. And a lot of times the trustee, I don't really want the responsibility for those particular investments. They might prefer to liquidate those and put them in an investment that's beneficial. We have a special holdings direction advisor. So we might turn the investment direction over to one, and we might have a second for special holdings, which might be family owned shares or something similar to that. Distribution advisor, and it's often a committee in my drafting or the trust that I've seen that says this is the person, maybe the family members who will be involved in, aware of what's going on in the kids' lives, and can give the trustee the better advice about, yes, this distribution should be made or not. The charitable advisor is something I've seen a lot, and I talked about that in my earlier presentation. Sometimes it's used as a charitable drain. Sometimes it's used for philanthropic clients who simply recognize that nonprofits change, and we want to be able to benefit charities that meet our objectives rather than a specific particular charity at a given time. A trust protector is just a little bit different role, and again varies by state. Some commentators will say this isn't quite accurate, but I look at the trust protector as the person who can help make sure the objectives that you've written into the trust can actually take place and happen. And so we give them very specific powers in terms of what they can do. Sometimes it might be to approve a situs change or other things. But Sarah, I'm going to turn that over to you and let you talk a little bit more about those roles.
Absolutely. So really the most common one that I saw was the investment advisor. That was really the key when I was working with directed trust. Most commonly that we would see come up is folks were asking, I really enjoy working with my investment advisor. I have a trustee named who isn't necessarily financially savvy. He doesn't want that responsibility. And also I think when we're talking about those different roles, and I know we touched on delegated versus directed trust. Of course, you always want to explain the fiduciary responsibility or any responsibility to the person you're speaking to, but it is really key here because that is the difference. So you want to make sure everyone involved, settler, actor, everyone understands I'm not delegating my authority, I'm directing my authority to you. You have the responsibility, I'm giving up control. And make sure that they understand there are two different options there. Go ahead.
We have a really great question.
Oh, yeah.
That I think
Let's
fits
answer
right
that.
in with kind of that conversation is whether all of the advisors are entitled to, which is a different question from whether they choose to be compensated.
So this is an excellent question, by the way, whoever asked this, thank you. So the hope is that when you are drafting these, you are very clear in the documents about whether or not they are entitled to compensation. Typically in the documents that I have prepared, I have always put in there, if you're hiring a professional, they're entitled to be paid, the individual making the decision, they're entitled to their normal hourly rate. If it is not clear, there are a couple different things you can do. So I've gone about this a couple different ways depending on where the drafting is. If it's completely ambiguous, you may want to get some sort of judicial settlement agreement or agreement by all interested parties that yes, we are going to hire this individual. This is the amount they are going to be paid. Make sure everybody is on board with the compensation structure if you can, or if you can't get everyone on board, get some sort of outside judicial approval for compensation. If this person has been named to act, there's not any clarity and they do expect to be paid. In other circumstances, I have gotten a release from the individual acting saying, I don't want compensation, I'm not asking for any compensation, that kind of thing. I don't know if you've seen anything different, Mary, or if you have any other advice, but that's commonly what I have seen.
So that's where I think the drafting, where you led with, is so important.
Absolutely.
Because can you imagine taking on the responsibility and not having any ability to get comp? So sometimes, and usually those that waive the compensation are the family advisors,
friends,
right? But if you're a professional advisor, and I serve sometimes as that, you have usually liability that's going with that, especially if your role is directed and you have the right to direct the trustee. So I think to the extent we're talking with our clients about using a directed trust, I always have a conversation with them about that. And if they waive compensation, we want to make sure we're talking about what the liability exposure is. and at least also talking about whether there should be insurance in place.
Absolutely. And I think that is, again, to go back, certainly when it's family members, when you have advisory councils, or even in that case, I shouldn't say it's always important. But it is an interesting question, right? If you go from professional investment advisor up until, the settler passes away, you've been compensated. Everybody understands you've been compensated. And suddenly there's this gap in language that says whether or not you're going to continue to be compensated in your new role, acting as, protector, advisor, whatever, under the terms of the trust. So you really want to look for that right away, in my opinion. Also, while family members, in my experience, most often do either waive it or, they're just not interested in the compensation. That is certainly not always the case, and that is absolutely something you want to get nailed down in writing right away before you begin any kind of work. Is anybody going to be interested in compensation or of again, an hourly rate, a lump sum? What are you looking for? Is the advisor going to continue at their regular rate? You want to, as Mary said, talk about liability. The hope is that you have documents that address this, but you just want to make sure you get that nailed down right away in case you don't, because it happens all the time where that language, I don't know if it gets forgotten or what it is, but or it's just assumed that everybody understands they'll be paid, but you don't always know that. So,
or even the conversation about it. So if the language doesn't address it, I think your point is the conversation. So the investment advisor is the really common
one. Absolutely.
And you see that a lot. And I thought we should just back up for a moment into like the typical structure
For sure.
of the directed trust, which, let's say I'm trying to do one for a client in Delaware, right? So then the issue is, I live in Nebraska. So then what I need to do to have my trust be situs in Delaware is hire what we call an administrative trustee. And that administrative trustee often serves a role of having just the role of creating the situs for you. So you go to South Dakota and you have a whole bunch of trust companies that specialize in that. So that is kind of their role, and they'll usually charge something, but it's usually a very reasonable amount of money. And then your advisors are under that. So you're still often naming a directed trustee. Then you're going to have investment advisor, distribution committee. You might have a tax advisor. You might have the charitable advisor. You might have the trust protector. And I'm just noticing some questions we should look at. So at what income level? And I will tell you that it's at all income levels in my mind, because the real answer to that question is, what are the objectives of the client? So you might have a client who has a special needs child and has maybe limited resources, wants to create a trust, but wants to have the family member involved in the distributions because they know the child and the child's needs. And maybe it's not a special needs child. Maybe it's the kid who's been married 3 times and had trouble spending, but we have a family member that stayed close to that child and wants to keep track. So I see the directed trust having a lot of value at almost any level. Do you see that any differently, Sarah?
100%. In fact, I would say I think perhaps it might seem to be rarely used simply because it is, I don't know if newer is the right word, but I think it has become much more popular in recent years as more attorneys become familiar, drafters become familiar with it. If you think about it, it really is, like Mary said, you can really involve, one of the hesitations when I'm talking with clients, when I'm sitting down to draft, who do we pick as trustee? That's sort of that huge question. And they're trying to think of the person that can fill all roles. And nobody can really do that, I don't think. I think it's always better as a team. So when you tell them, well, you can do a directed trust and you can keep your investment advisor who's been managing your funds so wonderfully all these years, and you can have a distribution committee. And so you can involve, your sister, your best friend, the folks, the voices you really want in the room if you aren't comfortable just leaving everything outright. And I think clients really, again, like Mary said, at every income level, really see the advantage of that. Quite frankly, sometimes the lower income levels, their money and their possessions, often, in my experience, they want to be more careful about who they go to and when. And so they like the idea of having more individuals involved. When I was acting as a corporate trustee, one of the big hesitations individuals had in utilizing a corporate trustee was it was so impersonal. They wanted the family voice to be there. They wanted the trusted professionals that they had been working with, accountants, investment advisors, lots of different people, their own attorney, their estate planning attorney involved. And so this is one of the models that we really promote to them as well. This can solve a lot of those problems. And also it can really shift the burden if you want, for example, your child or a family member to act as trustee, but they don't necessarily want to do everything. This can really redistribute the fiduciary liability weight, so to speak.
And I think one of the things that gets in the way, because I think you're correct that sometimes it's the lower, I mean, I use them at all levels,
Yes,
right?
of course.
I almost never anymore draft a trust that doesn't have at least some direction in it. It's uncommon. It might be just a trust protector, but there will be at least that, which in my mind creates a check and balance with the trustee. I think some of it is what you said, that they are still newer, right? I think it was only 2017 that the directors, it's not that many years ago. And it's a more complex drafting because you have to break out the provisions. I will tell you, the first directed trust that I did, I was very fortunate to reach out to the administrative trustee who generously assisted me in the drafting, quite honestly, and explained to me how it was a South Dakota trust, the first one I did. And she was actually involved in drafting the legislation for the state of South Dakota and took the complex and made it simple for me. I was like, oh, I get it. And so that trust, and the very first one I did used all of the roles that we've talked about. So the very first one I did was like, holy, I am right there now. But so that was great. And the next one I did, I think, was in Nevada. And the rules there are different, even though there's a similar model for those rules. But so one of the things, if you just haven't drafted these, familiarize yourself with the concepts. Find a directed trustee. Almost always, they have somebody who's an expert at helping you with the documents. Get a hold of somebody who's done it. Get a good document so that you understand the concepts. But the step one is just know what the concepts are, right? I'm going to do an investment advisor, and this is what they're going to do. Because I remember going through the trustee provisions the first time and going, well, wait, which one of these go to the investment advisor? And which one of these are still the, trustees? And which one of these are? And that is kind of the art of it and can be complicated to do, but to achieve that goal of what the client wants. And it's not the same. It's one of those things where I say, well, I don't really believe that we have little forms that help us get started, but our craft is knowing how to put those together to meet the objectives.
And I will say that is a very good chance you may have been, and I like what Mary said earlier, doing directed trust at some level and just didn't know it yet. A lot of us are utilizing trust protectors already in our drafting. I've been doing that for years, quite honestly. Same, it's in that idea, it's in that vein, thinking about, okay, we're going to make sure we have kind of a bifurcated role that has this very specific set of responsibilities. Again, specific set of language about compensation, all those things, that right there, that's the idea.
And I put up the slide that says common uses, and I'm thinking that we should add, as I do when I'm talking about asset protection, almost anyone really. Right. And I think that's a good point, that just adding a trust protector alone is a directed trust.
It's a directed trust. Absolutely. I agree. And I think what we were talking about earlier was that unique family situations for clients of moderate wealth. That captures just about everybody, that language right there. That's all wealth points. That's all family structures.
Well, let's just go through some case examples. And I'm glad I printed this out because the first box on this did not come up. So we'll go with this. So Sam and Lisa are in their late 50s. They have 2 adult children. And so this is a moderate net worth of about $3 million. $1.2 million of that is in investable securities. $800,000 is in a family cabin in Minnesota. I've had a lot of family fights about the Minnesota cabins.
God. It's always the cabin.
It's always the cabin.
Always the cabin.
Or the nativity set that was under the tree when they were in kindergarten. There's $400,000 in Lisa's small business design firm. And Sam and Lisa also each have small retirement accounts. They want to keep the family cabin available for future generations. They want to provide for each other. They want to make sure that the survivor is fine as long as they're alive. And then when they're both gone, they want to provide income to their children, but they don't want them to have everything outright because they want to keep the assets in trust for asset protection purposes. So, and feel free to pop in any thoughts from the audience on this, but what facts in this scenario, Sarah, might lend themselves towards a directed trust?
Well, certainly the family cabin, when I look at the scenario, the first conversation I want to have with the Sams and the Lisas, it's a great idea, but let's talk about it on a practical level. You know, who's going to be, you know, operating the day-to-day? You might want the cabin, but have you spoken immediately with your beneficiaries? Do they feel the same way about the cabin? You know, do they have one child who's living nearby, one who's maybe living out of state, maybe both living out of state? And what are their thoughts on the cabin's usage and payment of expenses? You know, do they want the funds that they're going to be inheriting in part going to paying taxes, paying for upkeep, paying for all those things? I think those are kind of the first, that's the first conversation that you want to have. And then when you think about the directed trust, you think about, okay, once we've had that conversation, who is going to fill what role and what makes sense? You know, who's going to be in charge of what?
So let me ask you just a question there. So you have a background as a corporate trustee.
Yeah.
So client comes to you and says, we're looking to name a trustee. And by the way, we have this cabin and we want you to police who can use it and when. Your reaction as a corporate trustee is?
Well, we're probably going to decline. No, I can't.
So if they instead said to you, well, what if we designed where we had a special holdings director
Sure.
who handled the cabin, would you act as trustee with respect to the rest?
Yes, absolutely, we would do that. That we would do. The reason is, you know, maintenance. Okay, Karen, thank you. That's exactly what I was about to say. Maintenance of a cabin or property inherited can be a problem. When I was a corporate trustee, yes, you know, there were certain exceptions to the rule, but for the most part, we did not want to be property managers. That, you know, carried its own level of liability, its own level of work. It depended on the dollar amount involved, of course, and things of that nature. But for the most part, yes. And my thought is, when I read this scenario, and I know this couple, I think many of us, but I feel like me particularly practicing in the Midwest, it's always the family cabin, it's always the family cottage, or they will have this little piece of land up north that just holds so many memories, and they have had their way of taking care of this piece of property, however they've done it for years and years, and they haven't really thought through the logistics of how that is going to change in the future. Whether or not other family members really want the property, even if they do want the property, do they want the financial obligations, the personal obligations that go along with maintaining that? I have seen so many different families where one individual says, well, we can turn it into an Airbnb and we can become landlords and we can rent it out. And the other individual says, absolutely not. You know, I live 10 states away. I fly back maybe once or twice a year. I'm never going to use this. Let's sell it. The real estate market in this particular area, let's just say hypothetically, super hot. I can get a ton of money. You know, you have that push pull there. So we don't want to get involved with that as the corporate trustee, and you as the trustee don't want to get involved in that either. So you want someone, you want to have that conversation. Then if they come back to you and say, okay, you know, we've got a designated individual who's going to handle all those problems, just like Karen said, fantastic. That's great. You've got somebody who's in charge of that right now. Wonderful.
So let's talk about the other objective and then kind of structure this trust. So they also want to keep other assets in trust for their kids rather than distribute them outright, because they want the kids to have the income, but they're very concerned with asset protection for their children. And my comment on that will be that, you know, once upon a time when I first started practicing, ooh, that sounds really bad. But people designed trusts, and it said, hey, you get 1/3 at 25 and 1/3 at 30 and 1/3 at 35. Unfortunately, I don't see a lot of people drafting that way anymore. And my comment on that is, how do you know where your kids, so your kid's 2 or 3, how do you know what your kid's going to be like at the age of 25 or 30 or 35? And sometimes they're more responsible at 25 than they are at 35, right? 35 is the day, or one too many times have been involved in a trust administration and had a trust share go outright to somebody who then the spouse files for divorce the next day.
Yes.
Technically, it's an inherited asset, let's be
Right.
clear, but yet, hey, judge looks at that and says, oh, you just got like a few million out of your mom's trust. So it was actually in my office, I had a long time ago, a guy who was in his 50s, had done quite well, and he brought his mom in, who was at the time about, I don't know, close to 80. And he said to me, and I was, much earlier in my practice at this point, he goes, I want you to explain to my mother the benefit of a third-party trust. I want her to create a trust for me that stays in trust for life. And mom's like, honey, you're successful. Why would I do that? You don't need... And he said, exactly, because I'm a litigation target, Mom. So I want you to put those assets in trust for me so that that is a backup for me if I get sued, because you creating a third-party trust for me is more protection. I could go up to South Dakota or Nevada and create a self-created asset protection trust, but this is a much better benefit. So I personally started talking to clients, well, rather than distributing assets outright at a certain age, let's talk about keeping a trust in place for life.
Yep.
And instead, maybe letting them become a trustee at some point in time, maybe having them act as a co-trustee for a while with somebody. So, but let's say in this case for Sam and Lisa, they say, okay, with respect to the investment assets and whatever we grow there, then what we want to do there is leave those in trust for life. So what kind of advisor might we want to consider to help with that?
Well, this would definitely be one of those situations where, and I completely agree with you. I really like the idea, and when I'm speaking with clients about just having that third-party trust in place there as a backup, because the whole idea is that you appoint someone in this scenario who you have a lot of faith in to make judicious distributions. Like you said, you might get a third distribution at age 35, they get divorced at age 36. More often than not, the assets have been commingled at that point because people just do, no matter what you tell them what to do. And so in this situation, I might recommend a couple things. One, maybe have the investment advisor, have this be a directed trust and have the investment advisor in charge of making distributions or making those decisions.
What about a distribution committee?
That was going to be my next thing.
Okay.
That was going to be where I went to next. So, in the scenario, this is really where you can say, okay, who in your life, would you be comfortable if you had a number of people, a range of people making input, giving input into when the distributions are made in this scenario? It can be really anyone. Is there someone you see commonly on your distribution committees? Because I have seen everything from, best friends of the husband and wife to other family members. I've seen people put, siblings in charge of each other's, which is a little complicated, I think. But when you're putting together a distribution committee, how do you start that conversation with the client?
So I will talk to them about, and one of the things that I do with all of these roles, by the way, is I always design them with the thought in mind that there's going to be a vacancy at some point. And so I define like the distribution as the distribution fiduciary, especially if I'm doing long-term trusts. And I might then name a distribution director or a distribution advisor. And then the duties go to the distribution fiduciary, which will mean if it's a person or committee, or if at some point an institutional trustee steps into that role. Because let's say some of these trusts that we do that are generation skipping and trust for a long time, these advisors are going to be gone. With that, I'll talk about how I design my own. So I've changed it just recently because my son was one of those kids who had some life challenges. And so I was very concerned about him having access to assets.
Sure.
And so I designed a directed trust with a distribution committee. And what I used was one family member. I used one close friend who'd been actively involved in his life and was close and knew. And then I included one professional familiar with trust and estate rules, but who also knew the family. And then I have a trust protector who can actually change those roles. But so that's a question, a challenge in any conversation with the client, because one of them, it's a really important one, when they want to name their friend or the siblings as the trustees of everything, I at least like the directed trust because now we can have them be just a distribution advisor. We can create a mechanism to replace. We can create a mechanism to change, consider the evolution. I mean, they might move. I've had clients
Oh, yeah.
move to Australia.
Oh, absolutely.
That's not
All
somebody
over.
who's present currently in the life. So
I do want to ask, as I've run into this several times, and I want to know what you do because I'm betting you have as well. What do you do when the client asks you to be the trust protector or you to be on the distribution committee? Do you accept? I don't always, but I have seen attorneys that do.
So my answer to that is it depends on, so I will never act as a trustee. And I won't act as a distribution director because that's a director role that's has a liability. The one and only role that I will accept is the trust protector role because, and now that's depends on the state laws and what it requires of a trust protector and how the role is defined.
Right.
But the one that I'll take on is one that can help replace and find if I know the family. And we actually have an entity because unfortunately, sometimes we run into people. I have a client who had nobody. I have a second one that I have to tell you that we're not going to accept. Like I had a client that she had absolutely no family left, and she actually designated me as her charitable director with the responsibility of where all of her funds went after death because she didn't want to decide, which I took. That was a great responsibility.
I can imagine. Yeah.
So
that's huge.
I do want to just go to the
sure.
last thing, and then let's just design that with those questions in mind. So we also have the business.
So anytime we have a business, first of all, as a corporate trustee, I feel like
I knew you. I knew. I couldn't wait to ask the question.
I'm sure. I feel like I'm giving corporate trustees a bad name here when I say we wouldn't accept it. But honestly, we're just hitting in this first question kind of the hot
What
button.
we're really doing is giving a mechanism that supports the corporate trustee, right?
For sure. But this is like that same scenario you brought up earlier. If you were to say to me, okay, corporate trustee, we want you to act on behalf of our, be our trustee. However, we are going to direct the business, control of the business, fiduciary responsibility of the business to this other individual, then that would be a different story. We are not going to be running the business. You most likely don't want to name a trustee put an individual in that position who would be in charge of running the business as well as managing everything else. So in this scenario, if there is a business interest involved, absolutely that's going to be a conversation, and one I would almost in every scenario recommend a directed trust in those situations.
So, and why don't I just take a shot at telling you how I might recommend
Please.
the design of this one. So what we don't have is where they live. So let's just put them in Iowa.
Sure.
Sam and Lisa are residents of, well, actually, let's use the state where I know exactly what the law is. So my home state of Nebraska. So if I create, because what we're talking about creating initially is really a revocable trust or trust for each of them during life. So I might say, well, but you're in Nebraska, so as long as you're in Nebraska, Nebraska's going to claim you. So we have to use Nebraska's directed trust statutes. So the first thing I would talk to the client about, well, we can design a directed trust, but what I'm going to make sure we have is the ability to change situs.
Absolutely.
So I'm going to have a trust protector with the ability to change situs so that if one or both pass away, we can move this to South Dakota or somewhere with more favorable laws, if possible. And then I would probably name a special holdings advisor. So I'm in Nebraska, so I have to have a general trustee. We're already situs there, so I don't need the administrative trustee on this one. That's more an irrevocable trust or post-death. By the way, what I do is I do build in the ability to name an administrative trustee for purposes of situs into every revocable trust in which we're using directed trust provisions to create their duties and make the ability to move it. So I don't have to add it, decant it, or do that later. And then, so I would have those provisions in there, but we're really not naming them. And so Sam and Lisa, during life, they can be their own trustees, distribution advisors. So we're really thinking about what happens post-death. So there, we'd have the administrative trustee provisions in place. I'd allow the trust protector to be able to appoint that administration trustee. I'd be thinking about an investment advisor for the investable securities, a special holdings advisor for the family cabin. And somebody mentioned the issue with funding that. So when I have a property like that that's going to require maintenance, and there's a lot of different times that issue arises, I'm going to allocate an amount of funds, and I usually use a formula to do it. And so we'll make sure that that maintenance is provided. And the alternative is to require the beneficiaries to provide it, but that becomes a problem if we have a beneficiary who hasn't done well. I've had quite a few fights about that. So usually what I like to do is fund the share. If we're going to hold the cabin in trust, let's have enough cash to pay the expenses of that cabin in the trust. And let's have a little bit of plan, because the other fight is, well, who gets to go the 4th of July weekend, right?
For sure, yeah.
And so have some provisions about how they do that built in, or you choose that advisor and have them create those rules for them. So I would have that. Trust protector would also have the ability to say, hey, we're going to leave this stuff in trust for the kids. And at some point, the kids can be their own trustees. And if they're not smart enough to realize I created this third-party trust for them and they don't treat it as the same, well, that's, their challenge. But I was going to give it to them outright anyway, so if they blow it, I'm just giving them the possibility of asset protection is what I call that. And you have to make sure that the trust protector does then actually have a duty to take action if one of them gets in a car wreck. I had a gal in this situation. She was trustee of her own trust. She was married to a guy who liked to drive her car drunk and hit and run with people. So she called me up and said, hey, you're trust protector. You need to fire me as trustee, which we did till all of that kind of passed by. So we have the family cabin, would be a special holdings advisor. We might have a distribution director involved in that. We might have a distribution committee designed kind of with the thoughts in mind. So what are your thoughts on that possible structure?
I really like that a lot. One alternative that I have done with the family cabin, and I know this is undirected trust, so I won't spend a lot of time on it, but I have, particularly for blended families, done an LLC for the family cabin. And if you're going to have issues with calendaring and divvying it up, and you have a lot of different voices, but they really want to keep the cabin, that can be wonderful. Because on top of the LLC structure, you'll also have an operating agreement, and I almost think that's what they need anyway. It's just who's going to put gas in the boat, who's going to hit it for 4th of July weekend, how is our repairs going to be split evenly? If one individual is using it all the time up there every weekend, somebody lives out of state, they're only there a couple times a year, is everybody's responsibility the same, that kind of thing.
So I want to make a comment on that. Directed trust notwithstanding, I always use LLCs. Yeah. And I wrap LLCs, I would wrap an LLC around that cabin, design the operating agreement with some provisions in there. So let's say we have somebody who's going to navigate that, but they're gone. So we put some provisions in there. I'm going to address the question on the screen as well. But I also wrap an LLC around investment assets, because that, to the extent you want an affordable administrative trustee, if you change situs, then you can have the investment advisor be in charge of that LLC. The trust just owns an LLC and isn't custodying the investment assets directly, which often makes the directed trustee more affordable. And by the way, when it comes to dividing the assets in the administration process, just take it in LLC. Of course, you want a 754 election in place if you do this pre-death. It depends on how you structure it. But that makes the distribution very, very simple. Okay, the fire destroying the property. First of all, I just want to remind everybody, but we have an issue with that with a case recently. And I'm trying to think, was that South Dakota? It was in the 8th Circuit.
Yep, it was South Dakota.
Was this okay?
I know what you're talking about, yeah.
Where the angry ex-wife burned down the house that was given to the niece, and the niece had no insurable interest. And so house burned down, nobody owns the house. So that question is actually a planning question that I talk about with clients is, by the way, let's make sure we figure out you guys die. Now that was a transfer on death disposition. So that makes Sarah's concept of an LLC much better, because we get the LLC providing the insurance during life, or at least an additional insured on the policy of the settler, so that we have that in place. But that insurance question is so important. I can't tell you after that case, to make sure that most times somebody dies, people aren't, well, some people are immediately thinking about what am I getting? But not everybody. Right. I was thinking about where we're burying my mom and the funeral service personally. So But ensuring as a planner, a very important role we can play is talking to them about insurance. That's a piece of the asset protection planning that we do. And in the directed trust concept, wow, who is responsible for making sure that insurance is continued?
Yeah.
Whether we have the LLC design or however we structure the trust. So great question.
Absolutely.
Okay, should we do another example?
Yeah, let's go to number 2.
So Morgan Rivera, and I'll flip the slide to that. Oop. So Morgan Rivera, successful entrepreneur. So she built a successful AI company. So question, are we in an AI bubble or are we not? Just kidding. Okay. And this company may go public, which if it's a great AI company, it may well. I'm waiting for somebody to design agentic AI for law. Her husband, Alex, is the beneficiary of a dynasty trust created by his parents. Morgan and Alex have a child from a previous marriage. They each do. And they have 2 children from their current marriage. The younger of their 2 joint children is disabled. So we have a closely held business, inherited assets, children from multiple marriages, and a disabled child. What do we want to be thinking about on this one?
Oh my gosh, so many things. So Morgan's company being pre-IPO, I think a directed trust can provide significant benefits in that scenario. With Morgan's company, if you have a directed trust and you have someone, again, we were talking about this in the previous scenario with business interests. I have never had an IPO or pre-IPO organization that I've had to plan for. Would this be a scenario, in your opinion, do you think having a committee weigh in, or who do you think would be the ideal individual to be have oversight in this situation?
So this is a little bit of a tougher one. And that first I kind of want to clarify that in this case, rather than our case example 1, we were talking about creating a revocable trust in the jurisdiction where the settlers live. If I have a client who is pre-IPO, so I talked in my earlier presentation about Section 1202 shares, and I'm going to assume if we have pre-IPO shares, they're probably structured that they have the potential to be 1202. So what I would be looking at for this client is an irrevocable trust, and I would be looking at another jurisdiction. So that's kind of my first thing. And then if you're pre-IPO, there is going to be significant regulatory issues related to who has any say,
of course,
over this particular asset. So there may be all kinds of restrictions that apply. So I will tell you that, and I have been in this situation, what I do is I consult with a really good securities lawyer and a really good transactional lawyer to make sure that what I design for them as a 1202 directed trust, I'm thinking about the tax exemption and the asset protection and where they want this to go, and I can readily muck this up. So typically what I have to do is get that special holdings advisor, and that special holdings advisor to qualify for this. Now, by the way, this is a pre-IPO case. If we just have Jodo Plumbing, totally different situation. But I'm
pre-IPO.
That was kind of what, So I want to make that point that this where I'm going is not for. But if I have a pre-IPO company, I'm gonna need to have a specialized special holdings advisor who has a relationship with the settler and is going to be satisfactory too. So if we go to the plumbing company, of course, and we're not pre-IPO, then the answer is different. We might want a special holdings advisor. I still prefer, like if you run a business and let's say you have a client who owns a small business and it's just them. A lot of times they have advisory boards that they participate on. And so they might look to somebody on that advisory board that they're close with to be a special holdings advisor. So there's a variety of things. It might be, a really trusted friend, but somebody who is business savvy. And again, this is an area that you really carefully designing the liability provisions and making sure you're protecting yourself with respect to what that advisor can and cannot do. And so jurisdiction, I'll tell you that this one, if I'm doing an irrevocable trust for somebody pre-IPO, I'm most likely going to be in Delaware. I might be in Nevada. I might be in South Dakota, but Delaware, just because pre-IPO, that's,
For
the
sure.
state. I'm sure somebody in Nevada and South Dakota will get mad at me for saying that, but I personally would be in Delaware. I
would
use
agree
South
with that.
Dakota and Nevada for a whole lot of reasons, but that
Yeah.
one.
We use South Dakota almost exclusively, but I can see in this scenario, Delaware would be very beneficial. So
I talk a lot about
Yeah.
jurisdictional arbitrage, and I will tell you that I have worked with a client in this situation. And what we actually did for one particular client, I'm changing facts so that it's not really, but let's say what I might do is create the one with the, like this might be a client that you say, well, this might actually be more than one
Yeah.
trust, right?
Right.
So we want to create an irrevocable trust in Delaware to hold Morgan's pre-IPO shares. And that's going to be in Delaware because that makes sense. The trust will be directed. We're going to select a directed trustee. If it's pre-IPO, so you have a lot of times cost is a consideration when selecting the administrative trustee. So remember, the clients don't live in Delaware. So now we do have to have an administrative trustee to create the situs of the trust in Delaware. So there are a lot of companies that this is all we do. We just act as an administrative trustee. We don't really want to invest your assets. We don't want to do anything else. We're just giving you a situs here in Delaware. But if you're pre-IPO, you might want a more sophisticated trustee. You might want to use one of the big names in the industry who's familiar with the IPO world. But then we might take and say, well, what about everything else? Inherited assets, and what are we going to do about these children from multiple marriages?
So I had a couple thoughts on that. Number one, with inherited assets, you do want to be very careful, I think, from a baseline, if you are representing a married couple, that you may want to speak about having them retain separate representation in this scenario. If they come to you immediately and they want to have a conversation about bifurcating their assets, I think you want to start with, if you have a common interest doctrine, I can represent both of you. But if you're going to be giving conflicting advice to the person who has the inherited assets versus the person who doesn't, you really want to be very careful in your representation in that scenario.
So I just want to tell you how emphatically I feel about what you just said. I would never agree to represent both of these. I've got one person going pre-IPO. I've got one guy with inherited assets. So there's the case, I talked about this in my earlier presentation in New York, that treated all of the assets that they put in trust, working with one lawyer, as marital assets. And so that's something that you always have to think about. This.
Careful.
I would want another attorney at the table.
Yeah.
But let's say that we're agreed on that.
Yes, absolutely.
So I'm representing Morgan because
Sure.
I already talked about the 1202 trust. Now you're representing Alex.
Okay. So in this scenario, I want to have a conversation. If he has a number of inherited assets that he wants to protect, first thing I'm going to have is a conversation with him about making sure that those assets are isolated and not commingled. I practice in Wisconsin, which is a marital property state, and you need to, of course, look to your local jurisdiction and what your rules are. But broadly speaking, with inherited assets, they can be kept separate in the event of divorce as long as there has been no commingling, and that can be very easy to do. You pay down anything joint, like pay a joint debt, that money's gone, that's been commingled. Obviously anything titled, if you purchase something together like a car or a piece of real estate, and you put both your names on it, if you use inherited funds, the money is commingled. It can even go to the point of, and I regret not having the citation right in my mind because it was kind of a fun case. But there was an argument on a divorce here in Wisconsin where inherited funds had been used to purchase the vehicle. It had only been kept in that individual's name. The funds were never jointly held. The argument was during the divorce that because that individual had parked their vehicle in the marital home's garage, that it was commingled.
Well, and we also have some case law right now, right? So to your point, which is excellent, we have some cases, because the other thing, and this is why we totally need to represent these separately. So we have some states, right? Massachusetts, Connecticut, and now New York, but we have one case, I think it was out of Massachusetts, that said bottom line, a mom had created a third-party trust for daughter,
Yes.
and that got treated as a property interest for purposes of marital rights. So what you're saying is, and regardless of states, you have to look at those state laws
Yeah.
to say, how is that going to work? But how do I keep his interest in this dynasty trust from being treated as a marital asset?
Yes, and that just means making sure that the funds aren't commingled. So to your point earlier about separate trusts for the IPO, we might want to talk about several different trusts here because we do see the question about the disabled child. We'll get to that in 1 second. This might be another example where I'm talking to Alex and I'm saying, if you want to protect these trust funds that you have received through this dynasty trust, you need to make absolutely sure that they stay separate from anything that you that is marital.
And we can go ahead and answer that. It's a little, because the answer on the special needs trust is a big maybe.
Yeah.
Right? So is the special needs trust is a particular creature. And again, the state law varies by state and what you can do. But basically, what that's available to is a disabled child who is on government assistance. And the special needs trust in general lets them say maybe have a single room at a facility rather than a double room, or you can pay for some extras. So your real question when you're talking about a special needs trust is, what are the assets of the family? So if I have a family with $100 million, they can set up a trust that's not going to have the limitations of a special needs trust. So if I have a very wealthy family that's not going to run out of assets, or even a modestly wealthy family, but they have a reasonable amount they can set aside for the child with special needs, I might create a trust that doesn't have the limitations of a special needs trust and give somebody the right. So it could be the trustee, it could be the trust protector, it could be your distribution advisor. Give them the right to change the trust share into a special needs trust if those resources start to become depleted in a way. And we don't want, we don't want is that trust to be treated as a resource and disqualify a disabled child on government assistance from being able to get assistance. So we only have a few minutes left.
Yeah.
So we won't really get to our other examples, but let's just talk about maybe on this one, because the one other issue is that we have the 2 children from the marriage, and we have 1 child from each other. And so we're going to kind of go with on this disabled child that we're going to say that Morgan's company does in fact go public, and she ends up being a billionaire. So then we're going to say at that level, right, that we don't need to carve out a special needs trust for that disabled. But by the way, the special needs trust is totally a possibility.
Absolutely.
If that IPO fails and she's now filing bankruptcy, then we're having a different conversation.
2 very different conversations.
But so let's say she's created this trust over here. So I've advised Morgan, why don't you create this trust? We're actually going to stack, and I'm going to create 3 trusts for Morgan. And because she's IPO. So what am I going to look at in terms of what I'm worried about is these kids from the different marriages.
Right.
Because the money that they didn't do a premarital agreement.
Nope.
So, and her company was formed after they got married.
Yep.
So it's a marital asset. So it's not the same situation as Alex. So she's taking those funds and putting them in trusts.
So when we're looking at that, first of all, you want to have the first conversation I would want to have is, what does equity look like in this situation to these 2 people? Alex has a child from a previous relationship. Morgan has a child from a previous relationship. They have their 2 joint children. What is their, how do they view equitable? But every family is very different. They might view all 4 children equally in terms of how the distributions happen. Morgan may want to provide for her child from the previous relationship differently than how Alex is planning. I mean, that child, maybe Morgan divorced somebody who is very, very wealthy, and she, wants to make sure that her special needs child has more, and she knows that her child from the previous relationship is going to be well taken care of. Alex might feel differently. Maybe he divorced someone who wasn't as well off and he wants to provide more to his child. So I want to make sure and get an idea of what equity looks like in this situation and whether they're going to be treating everyone the same. I really like in this situation to do a trust for each individual child with each individual terms, simply because in this situation, each of these children is very differently situated. So this isn't going to be a one size fits all, the trust that you talked about earlier. You know, somebody gets 1/3 at 30, 1/3 at 35, and the rest at 40, that kind of situation. It's a complex blended family here. And this isn't even a situation, I think, where necessarily a distribution committee would look the same for each child. Likely they would be different in each situation.
So can I give in the 30 seconds left? So that's why I designed 3 trusts.
Yeah.
So when I did the 3 trusts, trust 1 for the child from her marriage, trust 2 for the 2 that they have together, trust 3 for Alex and his child. And that was kind of my solution. And each of those would have various different advisors in those directed trust or director roles. So thanks very much for
Thank you.
listening to us today.